Hi, I'm attorney Kelly Longtin from Kelly Longtin Law, and today I want to talk to you guys about using beneficiary or transfer on death deeds. Now, in some states, these are valid. In other states, they're not. So I just want to begin by just stating that I practice in Massachusetts and New Hampshire, and we have not yet implemented the transfer on death deed. But I want to talk to you about what is a transfer on death deed. If you own property such as a home in your sole name, but you have not created a trust and transferred your property's title to the trust, it is virtually guaranteed that your beneficiaries or heirs will have to deal with probate after you've passed away. If the time and the expense required to create a living trust doesn't make sense for your situation, but you still want to avoid the probate process, a transfer on death deed may be the solution. Now, a transfer on death deed, also known as a beneficiary deed, does what it sounds like it does. It transfers your real property to your selected beneficiaries upon your death, similar to a payable on death designation for a bank account or a transfer on death registration for an investment account. During your lifetime, you continue to own and control the real property so that you can sell it, lease it, refinance it, give it away, or do anything else that you want to do with it that you choose to do. You also continue to be responsible for paying the mortgage and the taxes and maintaining the property. If you still own the property at your death, the TOD deed works to automatically transfer the property to your named beneficiaries without having to go through probate. And if you change your mind during your lifetime about whom you have named as beneficiaries in the TOD deed, you can amend it or revoke it at any time. So let's talk about how it is used. More than 25 states now allow you to use a TOD deed, and more states are considering adopting laws that allow them. You do not have to actually live in a state that allows TOD deeds to be able to use one, but the property must be located in such a state. The requirements for creating a TOD deed vary by state, but in essence, the process includes the following steps. First is to complete the TOD deed. With the assistance of an experienced estate planning or real estate attorney, determine the specific form or language required for the TOD deed to comply with that relevant state's laws. Remember to look at the requirements in the state where the property is located. A TOD deed will look much like any other property deed, but it will contain specific language that makes it clear that the deed does not take effect until after you or the owner has passed away. You want to name your beneficiary. So your beneficiary can be one or more people or organizations, such as a business or a charity. You may want to consider naming a contingent or alternate beneficiary in case your first choice for beneficiary passes away before you do. You want to be sure to use the beneficiary's legal name rather than categories or relationships such as my children. For example, if you're naming your two daughters as your beneficiaries, you should use Jane Doe and Julie Smith instead of my daughters. If you name more than one beneficiary, you should indicate on the deed how the beneficiaries will own the property, whether it's equal with joint tenants with rights of survivorship as tenants in common, each as to an equal 1/2 share, or some other form of co-ownership. You also want to describe the property. Be sure to use your property's correct legal description in the transfer on death deed. Your property's legal description may be found on the current deed recorded in the official property records, your sales contract, or your mortgage documents. However, legal descriptions are not always copied accurately. It is important to consult an experienced real estate or estate planning attorney or a title company regarding the preparation of deeds and the accuracy of a legal description on a deed. Then you want to sign the deed. If you're the property's sole owner, you're usually the only person who needs to sign the deed. However, if you're married and live in a community property state, or you have declared the property your homestead, it may be prudent or required that both you and your spouse sign the deed, a joinder or a waiver to show that your spouse has no objection. An experienced real estate or estate planning attorney or title company can ensure that your intended transfer meets all legal requirements and is properly documented. Now, if you co-own property with someone else as tenants in common, you can use a TOD deed to designate a beneficiary for your share of the property. If you co-own the property as joint tenants, all co-owners will need to sign the deed, and it will not be effective until the last surviving owner passes away. If only one co-owner signs the transfer on death deed, it will not be effective unless the signer is the last owner to die. Keep in mind that even if you or your co-owner sign a transfer on death deed, if you die first, the surviving co-owner can revoke that transfer on death deed before they pass away. So I want to just walk you through an example of how this works. Julie and John own property as joint tenants with rights of survivorship. Just means that when one of them dies, the other becomes the owner of the entire property. They sign and record a transfer on death deed that names their niece Stacy as the beneficiary. Now, when Julie passes away, John becomes the property's sole owner. And then at John's death, if John has not revoked the transfer on death deed or sold the property, Stacy becomes the property's owner. If your estate requires it, have the owner's signatures notarized. An attorney or title company can usually arrange for a notary to be present if it's necessary. The beneficiary does not need to sign the transfer on death deed. In fact, a beneficiary doesn't even need to be told about the deed, although it is usually a good idea to do so. However, the deed will be recorded and become a matter of public record, so it will not be able to keep it a secret either. Then you want to record the deed. File the deed with the proper land records authority, such as the county clerk, the recorder's office, land registrar, or office of land records in the county where the property is located. This will require paying a minimal recording fee. Recording the deed is a very important step because the transfer on death deed will be effective only if you record it. A beneficiary cannot record the transfer on death deed after you die and have it be effective. Again, consider working with an experienced real estate or estate planning attorney or a title company to ensure that the TOD is accurate and effective. Now, let's talk about the benefits of a TOD deed. There are a number of reasons why you might want to use a transfer on death deed. As I've already discussed with you, a transfer on death deed can be used to avoid the public and sometimes costly and time-consuming probate process. In an effort to avoid probate, and some property-owning parents will put their adult children's name on their existing deed. The problem with this approach is that because the adult child is a current owner, the parent's property becomes immediately subject to that child's creditors and divorce settlements and other issues. In addition, this approach may cause unintended gift tax consequences. If the property is subject to a mortgage, there may also be a real estate transfer, conveyance, or documentary stamp tax consequences, and even the inadvertent triggering of the mortgage's due on sale clause. A transfer on death deed avoids this problem because there's no immediate transfer or change in beneficial ownership. A child beneficiary has no ownership in or legal right to the property until after their parents have passed away. Another benefit of a transfer on death deed is that they can be created for really inexpensively and fairly easily. In addition, a transfer on death deed can be changed and revoked at any time. You just want to make sure that you follow your state's laws for the proper way to effectively revoke that deed. A transfer on death deed will take precedence over a last will and testament, even if the will was written later. So it's important to remember that a will cannot change or revoke a transfer on death deed. So let's talk about some disadvantages of a transfer on death deed. One of the downsides of a transfer on death deed is that you may have multiple beneficiaries. There are legal idiosyncrasies that you might not know about that can significantly impact the other beneficiaries' inheritances or result in an outcome that does not reflect your ultimate wishes. So for example, if a mom has 4 children and she creates a transfer on death deed, naming her 4 children as the beneficiaries of her home as joint tenants with rights of survivorship. Mom's oldest child dies, leaving 2 children. Mom is incapacitated and cannot update the transfer on death deed. When mom dies, the home will go to her remaining 3 living children, leaving the deceased oldest child's 2 children, mom's grandchildren, with absolutely nothing. However, if the transfer on death deed named her 4 children as beneficiaries of her home as tenants in common, then each beneficiary would inherit a separate but equal share. And in this example, the deceased child's 1/4 share will be distributed according to their estate plan and not automatically revert back to those surviving siblings. In sum, a transfer on death deed can be an inexpensive and simple way to avoid the probate process upon your death and transfer your real property to your intended beneficiaries. However, it is important to understand the practical and legal implications for your individual situation and wishes. So if you have any questions about using a transfer on death deed is appropriate for your circumstances, I just suggest that you contact a qualified estate planning attorney licensed in the state in which you own that property. So I want to thank you for watching this video today. I'm attorney Kelly Longtin, founder of Kelly Longtin Law.